Welcome everyone. Thank you for joining us for today's webinar. My name is Arun Verma and I am heading the School of Law at Raffles University. Raffles University is one of the best universities imparting legal education in India. I am thankful to our chairperson, Dr. Justice Meena V. Gombar, Vice Chancellor Professor Diwakar Goli for their encouragement in organizing this webinar. And I am also thankful to Professor Emeritus V.K. Kapoor and Mr. Sahin, my esteemed colleagues and dear students for their kind support. I welcome our esteemed guest, Professor Jennifer Trehan, for her kind support and accepting our offer to be a guest for today's webinar. Now, without further ado, we will turn this time over to the esteemed Professor Jennifer Trehan. Our resource person is a clinical professor, the Center for Global Affairs, New York University, Director of the Concentration in International Law and Human Rights, teaching a variety of courses in the areas of international law. She has been offering her services as a lecturer for 8 years at the Salzburg Law School Summer Program on International Criminal Law, Humanitarian Law and Human Rights Law. Member of the Council of Advisors on the application of the Rome Institute to Cyber Warfare. Previously, Professor Trehan was being enrolled in negotiations leading to the finalization of the crime of aggression in the International Criminal Court, Rome Institute. Previously, amicus curiae to the International Criminal Court related to the situation in Afghanistan, currently leading an initiative to have Union member states seek an advisory opinion from the International Court of Justice on the question of the legality of Security Council veto use while there is ongoing genocide, war crimes, and or crimes against humanity. Dr. Jennifer Trehan has got published a dozen book chapters and nearly 30 law review articles, prolific record of scholarship, with most recent book, Adjusting Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, Cambridge University Press 2020, having won 2020 Avila Book of the Year Award from the American branch of the International Law Association. The list of Professor Jennifer Trehan's accomplishments are too big to read within a strict time frame. Just a little housekeeping before we get started. Please type your questions in the chat box in your Google Meet control panel. I will bring them up during the presentation and we will also have time for questions at the end. Now, I would like to throw some light on the topic. Article 27.3 of the UN Charter establishes that all substantive decisions of the Council must be made with the concurring votes of the permanent members. The veto has been addressed during the annual working methods debates and is among the topics most frequently raised in the context of almost all discussions of Council working methods. Permanent members use the veto to defend their national interests, to uphold a tenet of their foreign policy, or in some cases to promote a single issue of particular importance to a state. Since 16 February 1946, when the Union of Soviet Socialist Republic, USSR, cast their first vote on a draft resolution regarding the withdrawal of foreign troops from Lebanon and Syria, the vote has been recorded 293 times. In a recent year, some permanent members have used this power to block regulations while ongoing atrocity crimes are being committed. Such votes have blocked condemnation of crimes, investigation and prosecution of crimes, as well as other measures designed to curtail or alleviate the commission of these crimes. There is no indication in the drafting history of the Union Charter that veto power was designed to be used in this way. The permanent members of Security Council have periodically utilized their veto power just to invoke the veto or the silent veto to block resolutions despite ongoing genocide, crimes against humanity, or crimes being perpetrated. In 2005 World Summit, following from the 2000 Millennium Summit, the high-level panel on threats, challenges, and change called on the permanent members in their individual capacities to pledge themselves to refrain from the use of veto in cases of genocide and large-scale human rights abuses. After the summit, the government of Costa Rica, Jordan, Liechtenstein, Singapore, and Switzerland, collectively nicknamed the Small Five, advocated the permanent members to refrain from using a veto to block council action aiming at preventing or ending genocide, war crimes, and crime against humanity. Similar calls have been voiced by members at large in the open debates on working methods. Now, I am requesting Professor to share her thoughts on her recent book published by the Cambridge University Press. Over to you, ma'am.
Great. Thank you so much. Thank you, Professor Verma, for that wonderful introduction. And thank you so much for your gracious invite to have me speak at Raffles University School of Law. It is a great pleasure. And thank you to everyone who has stayed up to hear the presentation. I know it's in the evening for you, where it's my morning. So I will talk about first the history of the veto. Where did this veto power come from? Then how is it being used, or I would argue misused, while there are ongoing atrocities? And then thirdly, I'll look at the current approach, which is to ask the permanent members to voluntarily refrain from using the veto. But I will argue that's proven insufficient. And then I will present what are the core of my arguments in my book, looking at the legality of the use of the veto while there are ongoing atrocities. And this is all contained in my book, so I will do here a short version of what is in the book. So if we go back to the early drafting, to what became in 1945 the UN Charter, with negotiations primarily at Yalta and Dumbarton Oaks. It was primarily the US, UK, and Soviet Union who were conducting the negotiations, with China brought in somewhat later. And then France was really a last-minute addition to being a permanent member. And in the debate, they don't use the word veto, they call it the principle of unanimity. So they need to be unanimous on, and what they thought they needed unanimity on was decisions to use force. So the idea was to prevent World War III. The US and UK in the negotiations proposed that if a permanent member was involved in the situation, the permanent member should not have the veto. The Soviet Union pushed back against this and said, no, in Chapter 7, we need the veto across the boards. And after contentious negotiations, the US and UK gave in, and we did end up with the veto even if a permanent member is involved. And you could just ponder, we would have, I think, a different charter and a different UN system if the US-UK proposal had gone forward. In San Francisco, where the negotiations were finalized at the War Memorial Opera House, other states did push back and question why there needs to be a veto power at all. And in the end of the day, however, there's a famous anecdote that the American delegate threatened to or tore up his charter. He said, you can tear up your charter if you don't want the veto power. So in the end, they got the broad veto power. Now, how would, what would they make of today's vetoes? Well, in 1945, we didn't have the field of international justice. The Nuremberg Tribunal just started in 1945, 1946, so there were no real discussions about vetoes and atrocity crimes. But I will point out, already in 1945, it wasn't an unlimited veto power because it is framed in terms of the purposes and principles of the UN, that the Security Council must act in accordance with them. And already in 1945, we did have early notions of what we call jus cogens, or highest level norms. So let me move to what are some historical examples, or Historically, we have calls for veto restraint as early as 1946, so 1 year after the charter was finalized. And we have a series of resolutions in the 1940s calling for restraint on the veto. More recently, it's been really the veto in the face of atrocity crimes that certainly I've been focusing on. So what am I talking about? Well, during the apartheid era in South Africa, we do have US, UK, and French vetoes. They don't fully block the Security Council, which is able to impose Chapter 7 mandatory sanctions. But it takes a long time, and it may have delayed the dismantlement of apartheid. During the Rwanda genocide, these same 3 permanent members did not want the word genocide to be used, and this may have contributed to the unwillingness to send troops. There also was simply a lack of will to intervene in 1994. So it's not that the veto was blocking. I think there also was no will to intervene. But when we reach the atrocities in Darfur, Sri Lanka, and Myanmar, we see very little out of the Security Council in the face of horrifically large-scale crimes in all of our situations. And sometimes this is a result of a veto threat. So note that a veto threat can block the Council just as effectively as an actual veto because it brings the Council to a halt. A veto threat is a permanent member saying, you must not use that language, we don't support that language, etc., and letting the other council members know that they will or could invoke the veto. So when we get to the crimes in Darfur, we actually see, I'm sorry, my voice is not very good today, a number of veto threats. And what they do is, in the face of alarmingly climbing death tolls, which ultimately reach about 450,000, with the crimes thought to be both war crimes, crimes against humanity, and genocide, we actually have the watering down, the weakening of UN resolutions. They weaken the sanctions regime, they weaken the peacekeeping mandate, and we have delayed deployment of peacekeepers. So it's the opposite of what the rest of the Council was ready and willing to do. Regarding Myanmar, we have one actual veto in 2007, and that would early on condemn the crimes. And the problem is when you can't even condemn the crimes, you know you won't be able to ratchet up to other measures. And if you can't condemn the crimes, it also somewhat sends a green light to the perpetrators on the ground. There is a Security Council member willing and able to protect them. The U.S. uses the veto extensively related to Israel, sometimes in the face of atrocity crimes, sometimes not. But maybe our worst series of vetoes recently has been related to Syria. There we have 15 vetoes by Russia, sometimes joined by China. And we have a set of vetoes that prevent recognition of crimes. The Security Council can't condemn a huge number of the crimes. And of course, there have been crimes on many sides in Syria, but a lot also by the regime which Russia is allied with. We have an attempt to refer the situation to the International Criminal Court, and that is vetoed, so that blocks our most direct route to accountability. And then there were 6 vetoes also related to chemical weapons. There was a joint investigative mechanism that was attributing responsibility to the side using the chemical weapons, and that was vetoed 3 times. There was even vetoes of humanitarian relief, and other humanitarian measures to try to lessen the bloodshed. So, and on the chemical weapons inspections, when those were first imposed, we actually see a decrease in chemical weapons attacks. And then after the 3 vetoes of the investigative mechanism, the attacks increase. So it actually appears to be quite a direct correlation between the veto and fatalities directly on the ground. And again, we have, large numbers of crimes, very large death tolls. And these are all situations where you had the other members on the council had proposed measures to try to alleviate the commission of the crimes, and so they would have attracted the 9 votes required for something to pass. So the way the veto is being used is very costly in terms of lives lost on the ground. So how has the international system responded? Well, in my book, I have a chapter, I call it Voluntary Veto Restraint, that they are asking the permanent members to voluntarily restrain themselves while there are ongoing atrocities. And we see this first out of the Canadian convened Commission, ICISS, International Commission on Intervention and State Sovereignty in 2001. Of course, they famously first formulate R2P, Responsibility to Protect, but within their report is a call for veto restraint, because without veto restraint, the agenda of R2P can be entirely blocked. I mean, we might ask, where was R2P in Syria? And I would say it was blocked by the veto. We then have, as Professor Verma mentioned, something known as the S5 group of states, Costa Rica, Jordan, Singapore, Switzerland, and Liechtenstein, calling veto restraint and other measures to promote transparency of the work of the Security Council. They proposed a General Assembly resolution in 2006. They later withdraw it. They come back with more support in 2012. But then the Office of Legal Affairs says it is a major question that requires a 2/3 vote, not a simple majority. And when pressure is put on states not to support the measure, they do withdraw it without a vote. We do have 2 current calls for veto restraint. The 2 current initiatives that are most prominent are called the French-Mexican Initiative, first proposed by France, and the ACT Code of Conduct. So the French-Mexican Initiative has 105 states supporting it, and it is significant because, of course, one of the permanent members has proposed it, and it is that there should be a code of conduct whereby the veto is to be restrained in the face of atrocity crimes, although it does have a carve-out in the vital national interests of a country they could still veto. It is framed as a political declaration. We then also have this code of conduct proposed by the ACT group of states, Accountability, Consistency, and Transparency group, and it calls for veto restraint in the face of atrocity crimes, and also states pledge not to vote against a credible draft resolution before the Security Council on timely and decisive action to end or prevent genocide, war crimes, or crimes against humanity. So it is signed by 122 states. We actually have 2 permanent members joining. It is the UK and France. But as I read that language, it also somewhat has a carve-out because the permanent members then pledge not to veto a credible draft resolution, leaving a little leeway for what is credible. There are other proposals. There's a group of elder statespersons known as the Elders. They included Kofi Annan and Nelson Mandela. They called for veto restraint in the face of atrocity crimes. The Undersecretary General for Legal Affairs, Hans Corell, at the UN called for veto restraint. In the United States, we even have a call for veto restraint. It was during the Obama administration. It was a commission chaired by Madeleine Albright and a Republican Senator, William Cohen, and they called for veto restraint. It's not currently the U.S. approach. And if you look at all of these different measures, and I analyze them in my book, you see slight variations. Which crimes are covered? Is the threat of the veto also covered? Is the threat of the crimes occurring also covered, or do the crimes have to start? Whether there should be an outside body to serve as a trigger. So do you need someone to declare the crimes are occurring, and then the veto should not apply? Whether a permanent member should issue an explanation of their veto, and as mentioned, whether there should be a carve-out if the permanent member is acting in their vital national interests, as France and Mexico support, or the veto should not apply, or should only be prohibited if there is a credible draft resolution. So those are the variations in these proposals. On the positive side, I would say over 20 years, we have fairly firm agreement that veto should not be used in the face of atrocity crimes, and 2 permanent members agree. On the negative side, I would say these are all soft law. A code of conduct is a soft law document. A political declaration is a soft law document. So they're not seen as binding. And I think our more significant problem is that we do not have 3 of the permanent members joining. So when 3 permanent members don't endorse veto restraint, we still have vetoes. So this is where we are today. So in my book, I have a different proposal. And just to say, I'm not in my book talking about eliminating the veto from the charter, because that would be a UN charter amendment. And charter amendments are veto-proof. That is, all 5 permanent members must agree to a change to the UN charter. So it is very hard to accomplish any kind of Security Council reform if it needs an amendment to the UN Charter. There was one charter amendment in 1965, increased the number of permanent members. It was originally 11, I'm sorry, I misspoke, 11 members on the council. The permanent members have remained 5. But there used to be only 11 in total on the council, and now there are 15. So we have had a charter amendment. But to get rid of the veto, they would have veto. So I don't even really propose because I don't see that as happening, as possible. So what I do is look at what does international law have to say about the situation. So I think of the veto, which is Professor Verma mentioned, is in Article 27.3. I think of it as the center of a system of international law. And I have 3 independent legal arguments. So first, and it's first based on Jus Cogens, which is our highest level of international law. I then look at the remainder of the UN Charter, and then I look at certain foundational treaties, such as the Genocide Convention and Geneva Conventions, and what do they say about the veto? Because the way it's read is the veto can be used any reason, no explanation required, absolutely as if it exists in isolation with our system of international law. So I'm here giving you, of course, a very short version of my legal arguments. They are over 100 pages in my book. So that is where you can find the full version. So I first look at if the veto is in the UN Charter and Jus Cogens is our highest level of authority, the veto is hierarchically below it in authority. And we say that the prohibition of genocide, war crimes, and crimes against humanity are at the very highest level. So I would argue at minimum, if you veto and the crimes are occurring, at minimum it is inconsistent with saying these crimes are protected at our very highest level and to freely veto. More aggressively formulated, I would say the permanent member may be facilitating the crimes. And the way the veto is used, this seems to be the case. When you block accountability, we block, the referral of the serious situation to the International Criminal Court. And it's also the veto power. We don't see proposals for a criminal tribunal for Myanmar put to the council. it would be vetoed. We don't see proposals for a Syria tribunal or a tribunal to address crimes against the Uyghur is not even put to the Council because it will face a veto. And we haven't had a resolution trying to refer the crimes against the Uyghur and against the Rohingya to the International Criminal Court because they would face certain veto. So at minimum, I say this is inconsistent with Use Kogan's, more aggressively formulated. It seems to facilitate the crimes when we're blocking accountability. And the state also is breaching duties of state responsibility. The International Law Commission, in its articles on the responsibility of states for internationally wrongful acts, Article 41.1, recognizes a duty of states to cooperate to bring to an end through lawful means any serious breach of an obligation arising under a peremptory norm of general international law. So there is an affirmative obligation to work to preventing these crimes and ending them, and this is not what we're seeing out of the Security Council. My second level of arguments deals with the UN Charter. So the veto is in the Charter. It's only one part. And if we look at the purposes and principles of the UN framed in Articles 1 and 2, they include respecting international law, respecting human rights, the obligation of good faith, and cooperation in solving problems of a humanitarian character. Current veto use seems very far out of line with these legal obligations. Under Article 24.2 of the Charter, the Security Council as a whole is bound to the UN's purposes and principles. And in my book, I argue if the Council as a whole is bound, individual permanent members cannot have greater power. They can't have power that is beyond the power of the Council. Therefore, the permanent members must be bound. Alternatively, I argue the permanent members are states, and states are bound by the purposes and principles of the UN. So that is my second line of argument. This is maybe the line of argument that states seem most interested in taking up and making these kinds of statements at the UN that the veto should be constrained at minimum by the terms of the Charter. A third level of argument that we could look at would be based on treaty obligations. So under the Genocide Convention, on Article 1 is the obligation to prevent genocide. And in the Geneva Conventions, in common Article 1 is the obligation to ensure respect for the conventions. All permanent members are parties to the Genocide Convention. They're all parties to at least the 1949 Geneva Conventions. Some are parties to the additional protocols, and some of the additional protocols also have this common Article 1. The International Court of Justice in the Bosnia v. Serbia case shows their serious content, serious requirements of this obligation to prevent genocide. First, it is triggered when the crimes are at serious risk of occurring. You don't need to wait till genocide is occurring. It is the serious risk that triggers the legal obligations, because obviously it's an obligation to prevent. And if you wait until they're fully occurring, you are not preventing them. The ICJ holds that the obligation is a due diligence obligation based on a state's capacity to influence. And here, if we think of the power of the permanent members, I would say they have a very strong capacity to influence by virtue of being permanent members, also in their bilateral relations. They often have relations with the country in question, and it's not solely limited to them on the Security Council, but every state. And this is actually broader than just the permanent members. It's the elected 10. It's actually every state should be doing what it can to try to prevent genocide. And the International Court of Justice also importantly holds that this is an obligation that applies out of one's own territory. So it is not only to prevent genocide within one state, but to prevent genocide in another country. Because here it was the obligations of Serbia regarding that it should have prevented genocide in Bosnia. And at the time of, for instance, the Srebrenica genocide, Serbia and Bosnia were separate states. So it is not solely an internal obligation. These same requirements are basically true under the Geneva Conventions. In Common Article 1, the obligation to ensure respect for the conventions. And those can, even the 1949 conventions, contain certain war crimes known as grave breaches and Common Article 3 violations. The ICJ in the Wall and Nicaragua cases holds that it is not, again, simply to try to ensure respect in one's own territory, but also in other states. One should try to ensure respect for the Geneva Conventions. And the International Committee for the Red Cross clarifies this is also a due diligence obligation to do what is in a state's capacity to try to ensure Geneva Convention protections. So it may be difficult to determine what exactly is due diligence, so what exactly is required. As you know, the Security Council has a variety of means at its disposal under Chapter 7, from provisional measures, from provisional relief to non-forceful measures to forceful measures. So there is a variety that it could do. But I would argue that when it is blocking the remainder of the Council from taking measures to try to address genocide, war crimes, crimes against humanity, and curtail or alleviate their commission, that is the antithesis of due diligence, the opposite of due diligence. On crimes against humanity, I didn't make a similar argument. You probably all know there is not yet a Crimes Against Humanity Convention. So it is in the drafting, and the draft says there is an obligation to prevent crimes against humanity. We don't yet have it, but I think you can make similar obligations based on general principles of international law that all states must work to try to prevent crimes against humanity. So to conclude, and I see a couple of questions, so I'm happy for others as well to put questions in the chat function. To conclude, what do I do in my book? I argue that states should bring up these issues at the United Nations or other venues and make legal arguments. They should move from voluntary veto restraint. Please restrain yourselves. It is not working. U.S., Russia, China do not join these. So they do not agree to voluntary veto restraint, even in the face of atrocity crimes. And unfortunately, this was true under Obama, so I think it may be true as well under the Biden administration. The voluntary approach is not working. So states should increasingly raise the legal questions. And whether in the Security Council or General Assembly, these could be very helpful to the elected 10 members of the Council, or to even other permanent members who want to try to prevent a veto or veto threat. Raise the legal arguments, and sometimes they have, even permanent members have made legal arguments, but they've made them more selectively. So the US and France and UK have made legal arguments, but only when they were complaining about Russian vetoes in Syria, not really across the boards. So they do make the legal arguments, but they do apply across the boards. States could also work towards a General Assembly resolution, recognizing that international law has something to say about how the veto is used in the face of atrocity crimes. And my ultimate recommendation is to seek an ICJ advisory opinion. So on a question, something like this, and for the General Assembly to do so, I mean, the Security Council could as well. I'm not sure the votes would be there. But they could ask the question, is all veto use while there is ongoing or the serious risk of genocide, crimes against humanity, or war crimes consistent with international law? Now, I've also been thinking of, could there ever be a contentious case? This isn't in my book. This is my more recent thinking and my more recent writing. And we do have a problem, for instance, under the Genocide Convention. a number of states have the reservation to Article 9, and it says they don't accept the jurisdiction of the ICJ if they're accused of breaches of the Genocide Convention. So in the way, I'm thinking of the Gambia et al. Case against Myanmar for breach of the Genocide Convention. Could you bring that, for instance, against China if there were a veto related to the Uyghur or Myanmar or something? China is one of the countries that has this reservation. So it would be difficult, and one would perhaps first have to challenge the legality of the reservation. The reservation was last upheld in 2006, but 5 of the judges said, basically, it is shocking that you have a reservation that you won't accept a case for genocide to be heard against you. And those 5 justices suggested it should be stricken. So one might need to go back and try to get rid of the reservation before there were a contentious case. So that seems difficult, but it is a possible route that I was thinking of. And there might be other possibilities of a really problematic veto being cast, and then either the Security Council or General Assembly can send an advisory opinion on that particular instance. Of course, advisory is simply advisory. It is not binding, but it does carry great weight. So these were my recommendations, and I had been meeting with states at the UN, somewhat slowed by COVID, but I was meeting with a number of states, the legal advisors, and trying to convince them to take up these theories. So I'm still in that process. So I think, going to end here and take some of the questions. So I could just...
Yes, thank you so much, Professor Jennifer Trahan, for this wonderful session and enlightening us on this topic. And we have some questions, so I'll read those questions. So our first question is from Mr. Pratik Tyagi. We have asked, can Security Council reform be prevented by a veto?
Yes, if it requires a charter amendment. So anything that could be done without a charter amendment, I think, is much more doable. So changing the composition of the council, or changing, who's on it, or who holds the veto power, or changing the veto is a charter amendment. Other things, if you can do, are more practice. So there could be ways to make the council more transparent. There is a proposal right now by Liechtenstein that every veto cast, there should be discussion of it within the General Assembly. So that is simply practice. When a veto is cast, we should discuss it. And then there could be more, light brought to the use of the veto. So that would make it more transparent. So kind of anything you could think of that would be more practice and practical could be done. But really altering the structure of the council, or, I don't think we can get rid of the veto power. So it is veto proof. So it's much easier to do smaller changes. I was in a meeting this last Wednesday, an ARIA formula meeting. Of course, it was remote. And they are actually broadcast on UN TV. So I just, you could tune into these as well. So I heard debate on the problem of when a country writes an Article 51 letter claiming self-defense, it only goes to the Security Council members, and other states were complaining they don't even see the letter. And then, maybe customary international law is forming, and they have never seen the letter. So something about, circulating letters. I mean, the opposite was, well, they all get an S number and are put on the website, but I guess the people aren't finding them. So something about, making it more transparent How do you address Article 51 letters and, maybe giving states an opportunity to respond to Article 51 letters, because the practice, sometimes they just go to the council and that's it. And then, that arguably forms, changes the law potentially. So, something about, how do you deal with the letters? You can do that kind of thing.
Okay, thank you so much. We have another question from Mr. Akash. Does crimes against peaceful gatherings be included in crimes against humanity, in special reference to present Indian scenario?
So prohibiting gatherings would not be. So crimes against humanity, so you could just look at the International Criminal Court statute online. It's Article 7 is the crimes against humanity definition. And I don't think I have my statute here at my computer, but it is more murder, extermination, torture, rape, enforced disappearances, apartheid, other inhumane acts, persecution. I think those are the crimes listed. So that's pretty much our most current definition of crimes against humanity would be the International Criminal Court statute. So you can see exactly what's covered, but prohibiting peaceful gatherings would not be covered.
What makes it difficult to amend UN Charter?
Yes, it is, particularly it's the veto. It's a high number of states. I forget if it's 2/3 or 7/8, but it's a high threshold, and they have to take it back and amend it for each country has to agree. But it's mainly the permanent members have to all agree. No veto for a charter amendment. So that is the difficulty, particularly when one's talking of the veto. There are, of course, ongoing discussions whether there should be additional permanent members. And I know India sometimes argues this, as does Japan and Germany and Brazil. And then the African states say, why no African members? So there are arguments, but you really need to get all permanent members to agree. So it is a high threshold of the UN member states, plus no veto. It's got to pass the Security Council without a veto. So that makes it very difficult.
Okay, thank you so much. I have a personal question. Whether your book, Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, is key to solve this issue?
I'm hoping that my book can solve this issue. That is the idea. It is born out of my teaching, that I was teaching so much international law, and my students were asking, why couldn't this be done? Or why couldn't this be done? And I said, well, what do you think? And it so often came down to the veto power. So my teaching basic international law, I seem to always be talking about the veto. So I feel like it is a new way to tackle the problem, to look at the legal issues, because the voluntary isn't working. I don't see the charter amendment working. So I'm saying, what does international law have to say about the veto? So I'm trying a new approach.
Thank you so much. I think the Security Council members, they should go through your book. So I think they will get better insight on this subject.
I hope so. I hope they do. I have done a book launch at the UN virtually, and sponsored by Netherlands, Sierra Leone, and Costa Rica. So it is the smaller states sometimes come out in favor of the rule of law. And I have presented to UN legal advisors, and at the International Criminal Court Assembly of States Parties, the same 3 states sponsored me. And in the past, Liechtenstein has also sponsored. So it is interesting to see sometimes the small states coming out for rule of law issues.
Okay, I think that is, we have already taken other questions. So I'm, handing over to Dr. Devender Kumar Tiwari for vote of thanks.
Good evening, one and all. It's my honor and privilege to extend a vote of thanks on this August moment. I would like to thank Mr. Arun Verma sir, the convener of this webinar, for giving me this opportunity. Thanks a lot, sir, first of all. And I would like to begin this vote of thanks with a quote. If time is money, then today's resource person's deliberation is millions for us. Definitely, it was mind-blowing. With this note, on behalf of School of Law, Raffles University, Nimrana, Rajasthan, India, I would like to thank our chief guest and resource person of the session, Dr. Jennifer, who graced us with her benign presence and guidance. Ma'am, you shared your experience with us about veto power, and your guidance is precious to us, and definitely we shall inculcate and make us aware about veto power. Thank you, ma'am, once again. We are grateful to Justice Dr. Meena V. Gombar, ma'am, our esteemed chairperson of the Raffles University. Ma'am, really we are thankful to you for providing us such kind of freedom and opportunity to create such platform for sound discussions. Our next source of inspiration is our patron, Professor Diwakar Goli sir, who has always been a source of inspiration and motivation for organizing such kind of activities. So I would like to place your good self on record. Thanks a lot, VC sir. I must say thanks to our active participants and audience. I shall be failing in my duty if I shall fail to show our gratitude to different deans of Raffles University, HODs, and my colleagues at Raffles University. I would like to thank the technical team and other non-teaching staff for their contribution in organization of this webinar. Finally, last but not the least, I would like to thank the convener of this event, Mr. Arun Verma sir, for initiation and execution of such type of activity. It was a great talk, and the esteemed resource person, Dr. Jennifer Trahan, depicted on very crucial topic of international importance. Finally, thanks a lot once again to everybody, and I wish you all a very happy time. Good night. Thanks and namaste.
Thank you.
Thank you. Thank you everyone for being here, and we are blessed to have such a wonderful session today. Thank you so much, Professor Jennifer Trahan.
Thank you. It's my great pleasure. Thank you for inviting me.
Thank you so much, ma'am. So we are winding up.